Good morning. We're on the record in the 53rd Circuit Court for the County of Sheboygan.
Right out of the gate, we're stepping into a live courtroom setting real stakes, real consequences. Pay attention. Even routine openings like this set the tone for everything that follows. Who's in control? Who's prepared? That matters more than you think.
We're beginning our criminal docket today with people of the state of Michigan versus Stephen Bursick. It's filed 20-6007FH. We have Mr. Bursick present with us from the Sheboygan County Jail by video.
Notice that appearing by video from jail, that alone tells you the defendant is currently in custody. Jurors aren't here yet, but optics like this can subtly shape how a case feels, even before arguments begin.
His attorney, Mr. McArthur, is in the courtroom, as is the prosecuting attorney, Ms. Goodrich. We are providing enhanced public access online to the proceedings today.
Enhanced public access translation. This case is open for broader viewing, possibly due to public interest or transparency policies. And yes, that can raise the pressure on everyone involved.
And Mr. McArthur, we're here today for a docket call. Do we know what the status of this case is? I know there's a couple other cases with a different counsel, and we're awaiting a ruling on a motion. I'm not sure what the effect of that is.
Here's where things get interesting. Multiple cases, different counsel, and a pending motion. That's legal chess. One ruling elsewhere could completely shift strategy in this case. So the big question is the defense waiting or buying time?
And this is or not?
Yes, with regard to this case, Your Honor, I believe, in talking to the prosecutor prior to coming on the record, I believe I've received all of the discovery that the prosecutor has at this point in time. I was advised this morning, however, that there are some transcripts that the prosecutor is seeking from a co-defendant's plea, which may have an impact on Mr. Bursick's case, and those have not yet been prepared.
This is a big deal. A co-defendant's plea transcript could reveal testimony, admissions, or even contradictions. That's potential leverage. Imagine building your defense or prosecution without seeing a key piece of the puzzle yet.
So as soon as the prosecutor obtains those transcripts, I obviously would like to receive a copy of those, and she's indicated to me that we would receive a copy of them. I also did receive a plea agreement yesterday from the prosecutor's office, which basically severs a plea offer from all three. Previously, there was a global plea offer.
Whoa, did you catch that shift? They went from a global plea deal covering multiple cases to a separate, individualized offer that can signal changing strategy from the prosecution. Maybe they're narrowing focus, or maybe cooperation dynamics have changed behind the scenes.
I have not had an opportunity to discuss that plea offer with Mr. Bursick at this point in time. And I do think that these transcripts may have some bearing on whatever plea discussions we have with regard to this case. So we are not at this point prepared to move forward to trial. I would ask that the court consider allowing us to have another pretrial conference, at which point in time, hopefully, all discovery will be provided to the defense, and we can make a reasonable decision as to whether there will or will not be a plea, or whether this will be proceeding to trial.
Classic defense move. Don't rush to trial without full discovery. Legally, they're absolutely right. Proceeding without all evidence could be risky. But here's the question for you. Is this about fairness or strategy?
Okay. Ms. Goodrich, any objection to that?
No objection, Your Honor. I believe that we're filing some motions in the other cases received an August 31st hearing date, so it may make sense to schedule this at that point.
Okay, I do see that was August 31st at 11:20 is the date that you were given for that motion.
Just like that, no major objection. That's silence from the prosecution. It often means they're comfortable with the delay, or they benefit from it too.
We could schedule this then for a docket call. I guess you want them scheduled just at the same time as the others, or 11:30? I mean, I don't want to.
No, that would be fine to have them all at the same time.
All right, so we'll schedule this then for a continued docket call then for August 31st at 11:20 a.m. And we'll schedule that to be held in person
Key transition moment. The case is officially delayed. No trial today, just more waiting. But in legal battles, time isn't neutral. It can strengthen a case or quietly weaken it.
Okay, anything further, counsel?
Not from the defense, Your Honor.
No, Your Honor, thank you.
Okay, thank you. All right, Mr. Bursick, have a good day, sir.
You too.
And I think we're, our next case is at 10. So we'll be in recess till 10.
And that's how quickly a courtroom moment ends. No drama, no verdict, just procedure. But beneath this calm surface, negotiations, evidence gathering, and strategy are all still in motion. So stick around because the real turning point might be what happens before the next hearing.